All rise. This court is now in session. The Honorable Dane H. Watkins, Jr. now presiding.
Thank you. Have a seat, everyone.
That's my mic.
Oh, I'm sorry. All right, counsel, give me just one additional moment to open a few things up and we'll get underway. All right. We're now taking up CR 2019-8197, State of Idaho versus Marshall Hendricks. And we're joined by Counsel Dewey for the state and Mr. Browning for the defendant. We're scheduled for sentencing, and I anticipate, gentlemen, that we're proceeding on sentencing today.
Yes, we are, and I had one letter. You have several letters in support of Marshall Hendricks that are included in the PSI. I have another letter of that nature from Jessica Hendricks' stepmother. She's the indicates she's the grandmother of two of the children listed as victims in here. She had a perspective on this that I wanted to share with the court.
All right, very good.
I understand Mr. Dewey has an objection to that, but I believe that it's appropriate as a letter in support of Mr. Hendricks.
Okay, counsel, what's the objection?
Your Honor, I'm not so much sure that this is a letter of support for Mr. Hendricks as it is a letter, a disparaging letter regarding the deceased victim. So I don't know that that's very proper at this point for the court to relitigate trial issues, whether that was, certainly I think that is inappropriate, and I ask the court to exclude the letter.
Okay, and you've had a chance to review it?
I have.
Very good. What I'm going to do is begin to review the letter. And Mr. Browning, do you have any information or view as to just the timing of it? Had it been submitted to those preparing the PSI versus now?
Actually, Your Honor, when I was looking for the letters of support in my files, I found this letter. I was looking for it this morning. And I thought that really the court should have grandma's perspective in this. There's a lot of talk about the grandchildren, or basically Rory's children, left behind. And this is the perspective of someone who has, is a relative who I thought her input would be.
Okay. Well, I note that the letter was drafted on September the 12th, 21. The reason for the question was to determine if this was simply just submitted at the last minute as opposed to one that could have been included among the other letters and received by the investigator. And so, given the date that it's September the 12th, and that's some weeks ago, as I indicated, I'll begin reading the letter and make a determination as to whether it ought to be included.
Actually, from last year, Your Honor. It is something that I had, considered whether to call her, but I think her statement is more, goes more to mitigation, as far, the point that we're at right now, I think it goes to mitigation. I think it's appropriate.
Judge, I guess I would just ask the court to look at the difference between this letter and all of the support letters that are legitimate support letters for Mr. Hendricks that are in the PSI. I don't think this is that type of letter.
Okay, thank you. And there is an apparent distinction between the two, and I believe this court has the ability to essentially bifurcate the issues and take the arguments as presented. So I will, as I instructed, begin the reading of the letter. Okay, I have an idea of how I would proceed with this. Having read the letter, I am not inclined, Mr. Browning, to include it in the PSI, given the age of the letter and some of the things that the state has suggested. On the other hand, I've read the letter, and to that extent, I would leave to counsel any argument that you would like to make regarding the letter, as this court is aware, as I know the parties are, that I sat through the proceedings, understand the dynamics that were involved in the case. I have reservations as to the value of the letter. After all, in the opening paragraph, it states that the author admits to not knowing Marshall and has nothing to do with Marshall really at all. On the other hand, the court believes that obtaining as much information about the circumstances surrounding this case and the defendant become relevant to the court for consideration of sentencing. Counsel has suggested that this might be postured in a way of mitigation, and I accept that position. Whether it has merit or not, I'll have to wait and see when I hear arguments. So I will preserve it because it is now a part of the record that the court has reviewed, but I won't be including it in the PSI. And Madam Clerk, if you need further directions on how and where to file it, let me know. But that's my indication.
And I guess, Your Honor, I would just note for the record that has not been, that's a statement that's not been cross-examined or anything like that, and that's unable to happen at this point.
Very well. Thank you.
And to be okay, Your Honor, none of the letters of support are ever cross-examined.
Well, I understand and agree, and there are, I think, distinctions that are made because of that. But in any event, with that, are either parties going to be calling any witnesses today?
Your Honor, there will be no witnesses from the state, but 2 victim impact statements.
Okay. Mr. Browning, will you be calling any witnesses today?
Will not, Your Honor.
All right, then how we will proceed is I'll invite the state to issue their invitations to those that will be making impact statements at this time.
Carrie Wessels. May she sit while she addresses the court? Your Honor, if
Yes,
she
that would
wants to.
be preferred, if you could pull that microphone forward unless you'd like to stand. If you do stand, ma'am, I'll have counsel pull that microphone and ensure that the reporter is hearing you.
If I sit down, I'll be really low.
Okay, very good. If you'll begin at least by stating your name and
Okay.
spelling it.
Your Honor, my name is Carrie Wessels, Kerry, Wessells. I'm Rory's mother. I just more or less have this for Marshall. Marshall, I forgive you. And you are a good person. I found this, I was reading and I found this, and I really believe this is for all of us. I am 100% responsible for everything I am and everything I am not, for my capabilities, for my incapabilities, for my joys and my miseries. I am the one who determines the nature of my experience. The nature of my experience in this life and beyond. I am the maker of my life, and we all are. Thank you.
All right, thank you. Mr. Dewey?
Your Honor,
Could I have you state your name as well? And counsel, would that be appropriate given her age? I know she was a witness during testimony.
I think
Maybe
that
initials, something like that.
either way is fine. I think the media knows that they're not to report those names.
Okay, thank you. You may proceed, ma'am.
Marshall is a good person with a big heart, and when I was younger, Marshall was a father figure to me, and I looked up to him. He knew how to put a smile on my face when I was down. He always cared for me and took me to go do things I loved. He's a really caring person, and he may have made the wrong choice, but he will always have a spot in my heart.
Thank you, ma'am. All right. Very well. Mr. Dewey, I'll invite the state to now make its sentencing recommendation.
Your Honor, if it please the court and counsel, I would prefer to reserve my argument for rebuttal of Mr. Browning's sentencing argument.
Okay, very good. With that then, Mr. Browning, I'll take your sentencing recommendation. After we hear from Mr. Dewey, I'll invite you, whether you have any rebuttal comments, since he's rather yielded that to you, and then I'll invite Mr. Hendricks, if he has any desire to express anything, that opportunity.
He does. May I remain seated? I've got, I was here this morning. I came in this morning, it was right after I busted my ribs and running this morning.
Did hear that.
It hurts to stand up or sit down or move, so if I may remain seated, I appreciate it.
You may.
What I'm asking for in this case, Your Honor, is, as I understand, we have a sentencing that can go from 10 to life on this conviction of second-degree murder. The jury has spoken. The court heard the evidence at trial, and I represent to the court and to the family that Marshall feels terrible about what happened in here. He didn't want to kill Rory. He didn't want to have a confrontation with Rory. He considered Rory a friend. And what happened on that day, again, Your Honor, you heard the evidence. Marshall did not seek out Rory. He did not seek out a confrontation with him. There was no attempt by him to find and hurt him. What happened was that Rory was, on that date, very high in methamphetamine, as we know from the autopsy report. He was very angry, so angry that he severely beat up Jessica and told her that he was going to do terrible things to Marshall. After he was done with her, he made threats to Marshall directly. Rory was known as someone who carried a gun with him behind him. And it was interesting, as you know, Your Honor, that one of the police witnesses at trial showed up, and he had his gun in exactly the same place that Rory was known to carry his gun, that is behind him, behind his back, where it could not be seen. And so we had Rory Neddo coming, wanting to know where Marshall was. He wanted to confront him, as he told his brother Jason on the way over. He's going to, quote, beat the brakes off that kid. He made other more violent threats to other persons, to Jessica and to Marshall directly. And Marshall believed that Rory was coming over to kill him. And Marshall believed, reasonably believed, that Rory was armed with a gun. And in fact, the evidence showed that Rory came, again, sky high on meth, and he was also indicated in the police reports that he also had a significant amount of marijuana in his system. And I wanted to call, I believe I can use this in sentencing. Your Honor would not let me use this in trial because of some disclosure issues. But the pharmacologist that we were going to call was going to testify that it was very high levels of methamphetamine, and that the effect of methamphetamine in conjunction with marijuana would make this person extremely agitated and extremely violent. And so on the way, again, Marshall he'd known Rory for a couple of years, and first met him in jail. And the two of them found themselves in jail because of abusing methamphetamine. And they'd made a pact with each other that they were going to help each other stay clean. And Marshall wanted that for himself, and he wanted that for Rory. Rory was able to do it for a while, but not for long, and he unfortunately fell back into the use of methamphetamine. And on this particular date, the violent aspect of methamphetamine, which had already shown itself in the beating that Jessica took, wound up in Rory coming to the scene armed with a loaded chambered pistol. There was a round in the chamber ready to be fired. there was a knife that was also right next to him in the car that he had with him. That was found in the car. It would have been right next to him. It appears that I don't know if he took the knife out or what, but it was found just within a foot or two of the loaded chambered gun, which was under the seat that Rory was sitting in when he came over to confront Marshall. In addition, we also know from photographs at the scene that Rory was armed with a set of brass knuckles in his pocket. And every police officer that was called as a witness admitted that this could do significant harm. Basically, you can fracture somebody's skull and you can kill somebody with brass knuckles. Rory had that with him when he was loaded on methamphetamine. He also had his hands wrapped to protect his fingers. And was there not for, just a friendly, I don't know what, there's no way you can conceive of his demeanor toward Marshall on that day as being friendly. Marshall tried to stop him. When Rory got out of the car, Marshall believed him again to be armed certainly with a gun, possibly with brass knuckles that he was known to carry. In addition, he got out of the car with a second person. Marshall didn't know who the second person was. Marshall didn't know that the person that was with him was Rory's brother. All he knew was that he'd been threatened, basically gotten a death threat from Rory, and the two men were approaching him. He pulled out a gun that he had. Did he own the gun legally? No, he did not. He described to the court that this is a gun that he had basically gotten some months earlier. It was a gun I think that he'd actually got from Rory. It was one of Rory's illegal guns. Rory was not allowed to possess a gun either, but he got it from Rory. And it was there in the car. He took it. He had it with him for his protection. And when Rory proceeded down or up, whichever you want to call it, the driveway, Marshall yelled out to him to stop, let's talk about this. And I forget the exact words that were used by Rory at that time, but I think he said that you weren't going to be able to do any talking when we're done. And he kept approaching. Marshall told him several times to stop. He did not want to shoot the gun. He had it pointed at him. He pointed the gun at him with the intention of stopping him. Rory's brother, Jason, got the hint. He immediately turned off, got behind the car. He stopped approaching. So it worked. I mean, he was pointing the gun at Rory, and Jason, when he saw the gun, realized that this is not the time to be approaching someone. So he went off to the side, but Rory did not. Rory kept coming. Again, as you may know from your years with drug court dealing with people that are on methamphetamine, generally they believe they're Superman, impervious to bullets, impervious to whatever. He just kept coming. And as a matter of fact, he was telling Marshall to shoot repeatedly. Marshall didn't do it because he didn't want to shoot him. He really didn't want this to happen. And the only time that he had to change his mind is when he let Rory get so close to him. And no police officer would ever let anyone get that close to him if they're pointing a gun at him, no police officer would allow anyone they believed to be armed to get that close. Marshall did, again, because it was his friend that was approaching him. And he was trying to talk him out of it, and it didn't work. And when Rory finally grabbed for the gun that Marshall had in his hand with one hand and then reached behind him where Marshall knew him to carry a gun, it was at that time that Marshall pulled the trigger. And the jury has found him guilty of second-degree murder for this. What I submit to the court, this is a horrible situation for Marshall to find himself in. Again, he didn't want to kill this man. He did not. Marshall was someone that he had put drugs behind him. He had, as far as he was concerned, put the life of crime behind him. Now, granted, it was not illegal for him to have that gun in his possession, the gun that Rory had given him. It was, he was not allowed to do that by law, and he's going to bear sentencing for that, today. But he had turned his life around. He'd stopped using drugs. He had he cleaned up his act. He had gotten a full-time job, so he was being a productive member of society, and all of a sudden his friend gets high on methamphetamine and comes after him in a violent rage, and reluctantly pulled the trigger. He didn't want to do that, so I am asking, Your Honor. I know that Your Honor has no discretion to give Marshall Hendricks less than 10 years. That we have minimum sentencing, and I submit to the court that this is not a case, where somebody has gone out looking for trouble. A jury is convicted of second-degree murder under these facts, and I would ask the court to sentence Mr. Hendricks to the minimum of 10 years, not because he deserves 10 years, but because under the law, I don't think you have any discretion to give any less. And that's all I have to say there, Your Honor. Thank you. And Mr. Hendricks is going to want to make a statement after Mr. Dewey is finished with his recommendations. Thank you.
Thank you. Mr. Dewey, the state's view.
Your Honor, I think what we've just heard is probably identical or very close to the closing argument in the jury trial. That's Mr. Browning's interpretation of the facts, and frankly, the jury didn't believe that interpretation of the facts, or they would not have convicted Mr. Hendricks. So I want to talk, since we're talking about, we're essentially hearing a closing argument, I want to talk about jury instructions. So the jury received an instruction, HG 702, malice defined, malice being the difference between manslaughter and murder. And malice is defined as, it says, malice is expressed when there's a manifested deliberate intention to unlawfully kill a human being. Malice is implied when the killing resulted from an intentional act, the natural consequences of the act are dangerous to human life, and the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. The jury found the defendant guilty of murder. The statute with regard to express and implied malice says, express malice is manifested a deliberate intention to unlawfully take away the life of a fellow creature. It is implied when no considerable provocation appears. And of course the court is aware that the difference between a manslaughter and a murder is that malice question, and certainly if there were no malice here, the jury would be able to look at something like a voluntary manslaughter, which would have been a killing upon a sudden quarrel or heat of passion. But that's not what the jury found here. The jury found malice. This is not a case of imperfect self-defense, of having a gun to defend yourself in a situation where you could lawfully defend yourself, and that being an escalation, making this into an illegal act. That's not what the jury found. The jury found malice, which is a prerequisite for a finding of murder. So while I appreciate Mr. Browning's interpretation of the facts, that's not what the jury found. The jury found that this defendant murdered a person, that he had malice aforethought when he pulled that trigger. So I don't think it bears fruit to try to relitigate or re-argue the case. I think if this argument that Mr. Browning has given is a reflection of Mr. Hendricks' attitudes towards the case, I have some discouragement about his ability to be rehabilitated in the future, because that's not an attitude of taking full responsibility for what he's done, based on the facts as they were found by the jury in the case. We have a defendant who appears before the court on his 5th and 6th felony convictions. He has prior history of failures on supervision, continuing criminal behavior, and imposition of time. He has an LSI of 29, and he's been convicted of second-degree murder. We'd agree that the court has no discretion to go below 10 years. Certainly, the codes would not support the court doing anything other than imposing a prison sentence here. So we would ask that the court impose a prison sentence of 12 fixed and 18 indeterminate on the murder charge. I believe that any other, the other charges will be swallowed up in that sentence. We don't have an issue with those sentences being concurrent. But I think it's important to recognize, and I hope Mr. Hendricks does, that his actions here, the wrongdoing here, goes beyond just having a gun in a lawful situation of self-defense. This was not a lawful situation of self-defense. The jury has spoken, and we should give more than just lip service to that fact and actually take those facts as the facts that we're dealing with. And if Mr. Hendricks does that, there'll be much greater chance for him being rehabilitated and paying respect to the person that he's murdered and becoming a pro-social, positive member of the community going forward. We have a restitution request that we would ask that the court order to Crime Victims Compensation and Ms. Wessels, Mr. Neddo's mother. That restitution request is in the amount of $2,886.40. We'd also ask that there be additional expenses available for reasonable counseling expenses incurred by the victim's immediate family directly related to this crime. And even though the victim impact statements today didn't really speak so much to that issue, the court does have Ms. Wessel's statement in the pre-sentence investigation of the impact that this has had on the people in Mr. Neddo's life, the man who the defendant shot. It has had an impact, and it's certainly easy to just speak ill of the deceased, but this deceased person had people in his life, and his death has affected people, and I think that's something to consider. But certainly there's likely to be reasonable counseling expenses into the future. So I would ask the court entertain that motion and make that order as part of the court sentence here today.
May I, Your Honor?
Yes, you may.
Just as a couple of things on that. Much as I respect my friend Mr. Dewey, counsel errs when he attributes my comments on mitigation to my client's attitude on remorse. They're two separate things. And I'm speaking freely. I believe I am allowed to speak freely under the law without involving Mr. Hendricks, in basically addressing the court that way. So I'm speaking to mitigation, Mr. Hendricks. Those are my thoughts to the court, not Mr. Hendricks' thoughts to the court. The second thing that I would mention is that just about everything that I said is not my opinion. These are facts that came out of the jury. The weapons that were found in the court, those were admitted by the police. The brass knuckles in Mr. Neddo's pocket, there's photographs of that by the police. I didn't make any of that up. The statement about him going to beat the brakes off that kid, that came from the decedent's brother in a statement to the police. These are not things that I've made up. These are facts that were adduced, at the trial. And the fact that Mr. Hendricks did not shoot Mr. Neddo when Mr. Neddo arrived on the scene, that's fact. That he repeatedly told him to stop, that's fact. Now those are, and I realize that Mr. Dewey was not there at the trial. Mr. Spencer was there at the trial. But again, I was not, I'm not giving a different version of the facts. Those are facts that were right there at the trial. The other thing was the comment on malice of forethought. I believe malice of forethought is first-degree murder. That malice is an element of second-degree murder. Malice of forethought, there was no planning on any of this by Mr. Hendricks. Again, he didn't want this to happen, so that's all I have to say, Your Honor.
Okay. Can I clarify that point of law, Your Honor?
I don't mind doing that, allowing you to do it.
Sure.
I'll take your statements. I was going to make a statement regarding it anyway, but Mr. Dewey, you may speak.
Your Honor, malice of forethought and malice are not, there's no distinction between those two terms when it comes to murder. And certainly under the code, malice of forethought is required for a murder. Premeditation is required for first-degree murder, which is not what we're arguing.
Thank you. And so, Mr. Browning, I take your distinction of that premeditation to be consistent with your statement regarding the planning or otherwise. And so I think we're on the same page with regards to that and the elements of second-degree murder. All right, well, counsel have both presented their recommendations and statements along with the impact statements. Now, Mr. Marshall, I would invite you, if you're interested, to express anything before I pronounce sentence.
Yes, sir. Yeah, I screwed up, possessing a firearm in the first place. I had no business having it. May I address the family?
Actually, the message will be received as they are here, but I would prefer that you look directly at me and speak to me.
Words can't describe, how sorry I am for all of this. And I'd do anything to go back and change it. Anything. Words just can't express. I'm sorry. Yeah, I know them well. I'm sorry.
Thank you.
I didn't want any of this.
All right. Appreciate everyone involved in today's sentencing. Mr. Hendricks, are you fully satisfied with your counsel
Yes, sir.
throughout the case? Thank you. And counsel, is there any legal reason why the court should not proceed and sentence Mr. Hendricks?
No, Your Honor.
Okay, thank you. Well, let me begin first by a few statements to you, Mr. Hendricks, regarding my desire to have you look at me as opposed to directly at the family. I knew that you had expressed remorse during the course of the trial. I knew that you had expressed remorse in the PSI. At sentencing, it's most appropriate to just look at the court. I know the family is here. I know they received that. I hope you understand the reasons behind me wanting you to focus your, at least, eyes on me as opposed to others in the courtroom. So I wanted to share that reason with you.
Thank you.
In addition, and I'll have more comments about your statements in a moment. In addition, let me share, Mr. Hendricks, that this court has 4 primary objectives that are important to be considered when fashioning a sentence. The first is protection of society. The next is deterrence to you and to others. Third is punishment for the wrongdoing. And fourth is rehabilitation. And in your circumstances that you present before this court, all are very important and all have, I think, a very significant response by the court to these objectives. And I'll speak to them each individually in some way or another. In addition to the arguments that I've heard today, the court has very carefully reviewed the pre-sentence materials, including those statements or letters that were submitted. My reaction to those letters is that those individuals that submitted those see you for what you are. I think you are a loved individual. Those that wrote letters recognized the struggles that you've had over the course of your life. And today the court heard 2, I would say, very compassionate statements from others. The first, 2 things stood out to the court in my mind. First is that expression of forgiveness, which is significant. And 2, the discussion of consequences associated with choices. The other statement is compelling. An individual who testified at trial, I found, frankly, for what it's worth, one of the more credible witnesses during the course of the trial and the tenderness that was expressed during that trial and just the sad circumstances that that young lady found herself. Today, there is also in my mind an expression of forgiveness and a description of, as she described, a father figure to you. All of these things are very important to acknowledge and are redeeming in the court's evaluation of what an appropriate sentence would be. But it's not the only consideration that the court must undertake. As I go back to those objectives, protection of society is such an important factor, and in this case, the outcome, the consequence of choices could not be any more consequential or dramatic, where someone had lost a life. You used the language screwed up, and that began with the possessing of a firearm. There were elements of self-defense in this set of circumstances and facts that were presented to the jury, and this court relies upon the findings of the jury. It is appropriate for this court to consider all of those circumstances for sentencing. I don't want you to think at all that the court would ever overlook the findings of the jury, that this is in fact a second-degree murder offense, and this court will sentence you in that regard. One of the, I think, most difficult challenges that this court has in fashioning a sentence is how to reconcile this prior criminal history. And it frankly sets you apart from the many loss of life cases that this court has been called upon to render a sentence. So I'm balancing the facts and circumstances, the jury's finding, and what glares at the court in review is this accumulated over the course of young adulthood and into these latter years at your age at 32 of one offense after another. As I review those offenses, I want you to understand that this court does not view those prior offenses as victimless. It would be a much more challenging decision for the court had you appeared with offenses that involved violence or additional weapons charges. As I know the parties have reviewed, many of these offenses deal with either substances or property. Also, I know that you've had opportunities in the community with probation. You've had an opportunity for a retained jurisdiction, and you've had prison as well. And you testified to that at trial. The relationship with Mr. Neddo and how you became friends. I would call out the statement in the PSI on page 5 where you acknowledge that you never should have had a gun. That is an aggravating factor in this case, and one wonders, had you not, what the outcome would have been. Was there way out? Was there way an out, or an out of this set of circumstances that began to unfold perhaps days before this killing, hours before the killing, or even minutes before the killing? With all of the testimony that this court heard, in my own common experience, understanding all of the things that your counsel even argued in terms of mitigation and circumstances, I'm left with the conclusion, and I hope you agree, that there very much was a way out of this without taking a life. And, you know, you may struggle with my statements when I say that, and as we get closer to the event, maybe it becomes more challenging, but I am convinced that there were alternatives to you removing yourself as one who should not have possessed that firearm, did, and then ultimately pulled that trigger and took the life of another. And you live with that. I would highlight that I have understood from the very beginning proceedings in this matter that that has been upon your conscience, and you express that today, and I accept that you wish this had not happened. So the deterrence is the difficulty. What is a sentence that I can deter you and others from committing again? Rehabilitation, in all of my interaction with you over the course of this case, I believe you're right for the kind of rehabilitation that is needed. Because of the statutory limitations that this court has, in large part of discretion, I need to focus on that because you will be, at some point, assuming you conduct yourself in an appropriate way while in custody, released. That's a Department of Corrections decision through parole, but given the state's recommendation, they expect that as well. And then lastly, punishment for the wrongdoing. I don't have a lot to say about that other than you will be given credit for the time that you've served in custody on these offenses. Beginning with the unlawful possession, I sentence you to the maximum of 5 years fixed, with the more dominant offense of second-degree murder. The court is going to impose an 11-year fixed with a indeterminate period of 25 years. That is a 36-year sentence. It exceeds what the state had asked for. I do that primarily because of your appearing before the court today with a very significant prior criminal history and the loss of life being so consequential. I think it's necessary to have the state in your life well into your latter years of life, and if at 36 or 7 with that sentence you're close to 80. And I think that's the appropriate indeterminate period. These will run concurrently. The court will impose the $5,000 compensatory fine and a $5,000 fine. The court accepts that there will likely be restitution related to counseling if necessary, but that would remain open. That figure of $2,800, is that conceded by the state or the defense, Mr. Browning?
Yes, Your Honor.
All right. Mr. Dewey pronounced or stated that exact figure. It was $2,800. I know there was some change.
86, 28, 86, 40.
86.40. To you, Mr. Hendricks, do you have any questions for the court or your counsel?
No, Your Honor.
Let me advise you that you have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 expires in 120 days, and Mr. Browning will explain to you whether any of these remedies or options of relief have any merit in these circumstances. Okay? Very good. Thank you all. You may be excused.